Chapter 32, Equity Pleading, Sec. 170. Equity Pleading in Code Practice. What does the term equity pleading convey to the mind of the student of the code system? Is there anything in the code system that may appropriately be designated as pleading in equity, or equity pleading? The code abolished the formal distinction between actions at law and suits in equity, and the result was that all formal matters or rules of equity pleading and practice were abolished and the two systems of law and equity reduced into one. Whatever substantive distinction there may have been, and some there was, between pleading in law or in equity was not more affected than was the distinction between law and equity. It is well understood that the rules of pleading provided by the code apply and govern pleading in all actions at law or in equity. It is also well understood that the code did not reduce all previous rules of pleading to specific enactment. The code did not incorporate into its provisions all the former rules of pleading prevailing either in law or in equity, nor did it abolish or repudiate such of the former rules either in law or equity as were not specifically mentioned. Some of the code states, however, have been reducing the great majority of rules of pleading to statutory form. It follows, therefore, that in code states where all of the rules of pleading have not been reduced to statutory form, resort must be had to the old systems for the same. Such of the old rules of pleading either in law or in equity, as are useful or necessary, are still to be observed and adopted in code practice. An examination of the practice in equity under the old system will disclose that some of the rules of equity pleading were formal. These the code abolished as did common law rules, which were subject to the same objection. A study of these formal rules is important or essential only as it may be necessary to come to the new system by the route of the old. The inherent nature of a cause of action in equity being radically different from the nature and character of a cause of action at law, it follows that there must be some difference in the manner of statement of the two. But a cause of action either at law or in equity is to be stated in ordinary and precise language. It will be found that many rules of pleading are common to both classes of actions. Courts of equity paid less attention to technicality than did the courts of common law. Courts of equity regarded substance rather than form. In some cases under the code, courts are not so exacting in suits in equity as they are in actions at law, respecting the particularity or the fullness with which the facts constituting the cause are stated. This was the former rule in equity, and was applied in cases of such nature that it was difficult to ascertain and state all the facts minutely. The rule was generally applied where the facts are within the knowledge of the adversary. There is still greater liberality in the practice under the code to suitors in equity when appealing to the extraordinary powers of a chancery court. Courts granting extraordinary relief sometimes extend a lenient hand towards the pleader. Sec. 171. When resort may be had to equity, equitable jurisdiction. Some knowledge of the nature and subjects of jurisdiction of courts of equity is essential to knowledge of pleading and practice in those courts. The jurisdiction of such courts is classified into original, concurrent and auxiliary. The numerous kinds of modern equitable remedies, according to their essential elements, range themselves into 10 general classes as follows. 1. Declarative remedies. 2. Restorative remedies. 3. Preventative remedies. 4. Remedies of specific performance. 5. Remedies of reformation, correction or re-execution. 6. Remedies of rescission or cancellation. 7. Remedies of conferring or removing official functions. 10. Remedies of establishing or destroying personal status. The subjects of equity jurisdiction briefly stated, are the following. 1. Equity recognizes titles which were entirely ignored at common law. An example of this is where a chosen action is assigned, the assignee having no standing in the common law court, but in equity his right is recognized. 2. The enjoyment, devolution and transmission of legal titles are sometimes controlled by equitable doctrines, so that the rights of parties thereto may be very different in equity from those to which a court of law would give effect. 3. Trusts are within the exclusive jurisdiction of courts of equity, excepting a trust ex maleficio which is within the concurrent jurisdiction of courts of law and equity. 4. In the case of mortgages, The Court of Equity recognized an independent title known as equity of redemption. 5. Accident and mistake. 6. Equitable rights growing out of fraud. 7. Growing out of the general subject of fraud is that of notice, which embraces also the subordinate equities of bona fide purchasers, and the application of purchase money. Notice is a doctrine which is recognized for the purpose of protecting equitable titles. 8. Springing from the general head of fraud is estoppel, which is an agency of the law by which evidence to controvert the truth of certain indisputable admissions is excluded. 9. Election, a doctrine whereby a party is compelled to choose between inconsistent benefits and is precluded, after having once exercised his choice, from insisting upon rights which he would otherwise be perfectly free to assert. 10. Conversion, by which is meant a change of property from real into personal, or from personal into real, not actually taking place, but presumed to exist only by construction or intendment of equity. 11. The general head of adjustment includes the subordinate heads of set-off, contribution, exoneration, subrogation and marshalling liens. These equities are called into play for the purpose of securing orderly and equitable adjustment of liabilities against parties by whom, and in favor of those to whom they are justly due, and they all depend upon the general equitable principle that burdens ought to be thrown on those who should justly bear them, but only in their due proportion and in their proper order, and if benefits should be secured to those who are by right entitled thereto, with a just regard to the rights of others. The right of set-off, though of equitable origin, has been adopted by statute in code states. A right of action for contribution may or may not be an equitable right of action, depending entirely upon the facts and circumstances of each case. If the facts are of a complicated nature demanding the exercise of the equity powers of the court before the amount can be ascertained, then it is an equity case. But if the amount may be readily ascertained and without difficulty, or if it is known in advance, the action is legal and rests upon the implied promise to pay. Liens is the last equitable right to be mentioned. A lien was a right at common law, but in equity a lien may exist wholly independently of possession, and under circumstances which would give the party no common law right at all. A vendor's lien is an illustration. Equitable remedies is a general division of chancery jurisdiction. Equitable jurisprudence is made up of a system of remedies. Under this comes specific performance, injunction, reformation, rescission and cancellation, bills for account, for dower, for partition, partnership bills, creditors' bills, bills for discovery, bills quietiment and the appointment of receivers. Sec. 172. Remedy at law must be inadequate to invoke equitable jurisdiction. The fundamental prerequisite to invoking equitable jurisdiction is that the remedy at law is inadequate. This was the principle upon which the English Court of Chancery acted, and it has been recognized at least by the courts of this country which have followed in the footsteps of the English system. In the federal courts, and the courts in those states where the formal distinction between the suits in equity and actions at law still prevail, the inadequacy of the remedy at law will send the suit out of the court of equity upon demurrer. In the code states where the formal distinctions between law and equity have disappeared, the attitude of the courts towards this question is different. There being a union of law and equity, and the formal distinctions being disregarded, the practice in some states is such that where equitable relief is sought, but it appears that the remedy at law is adequate, the case will not be dismissed for want of equity, provided enough facts have been stated to entitle the plaintiff to legal relief. In such case the action may be retained and tried as at law. In some code states, however, notably Wisconsin and Oregon, the practice in this regard is the same as in the old system, in federal courts, and those states still following the English system. That is, the limitation on the jurisdiction of such courts is measured by the rule that no suit can be entertained where the plaintiff has an adequate remedy at law. This, practically, means in the federal courts, that though the party is in a court where the same judge administers law and equity, he must dismiss his equitable suit, and file a new action at law if the latter remedy is adequate. A court of equity may of its own motion refuse to entertain a suit in respect to matters cognizable at law. The remedy to be pursued by the party is to interpose a demurrer, which will result in a dismissal of the suit. Sec. 173. Misjointer of legal and equitable causes. It follows that in the courts which still pursue the old chancery system, there can be no joinder of legal and equitable causes in the same bill. The remedy for such irregularity may be either a motion to dismiss the bill, or a demurrer thereto on the ground that the remedy at law is adequate. The demurrer in such case should be directed to the part of the bill which the demurrant desires to have eliminated. The action which may be taken by the court in such case will depend upon the facts stated. If the two claims are clearly severable, and it appears that the remedy for the legal claim at law is adequate, the bill will be dismissed upon demurrer. If there is a distinct complete legal claim, as well as an equitable cause, the court may direct that they be separated and stated as separate causes, one at law, and the other in equity in the same court. 316. Sec. 174. Law and Equity in the United States Courts. Article 3, Section 2, of the Federal Constitution provides that the judicial power of the United States shall extend to cases both at law and equity. The original act organizing the federal court provided that the circuit court should have jurisdiction over civil suits both at common law and equity. General equity powers were not conferred upon the district courts of the United States. These courts were only invested with some special equity powers, such as the enforcement of liens of the United States government for internal revenue tax against lands. The original Judiciary Act of 1789 conferred general equity power on the Circuit Court of the United States, which together with several other provisions hereafter to be enumerated, have resulted in constituting that court the Chancery Court of original jurisdiction of the federal government. The result has been that the law cases have been filed in the district courts and the equity cases in the circuit courts. Both classes of cases, however, may be tried before the district judge who is a judge of both courts. The other provision of the Judiciary Act which contributed to the constitution of the Circuit Court as the Federal Equity Court was that which provided that suits in equity should not be sustained where there was a plain, adequate, and complete remedy at law. The provision in the original Judiciary Act that in trials of actions at common law, the laws of the several states where the actions are brought should, when applicable, and not at variance with the laws of the United States, be regarded as the rule of decisions to be followed by the United States courts, together with the provisions previously mentioned, resulted in the perpetuation of the formal as well as the substantive distinction between actions at law and suits in equity. In 1872 an Act of Congress was passed to the effect that the practice, pleadings, and forms of proceeding in civil causes, other than equity and admiralty causes, in the circuit and district courts, shall conform, as near as may be, to the practice, pleadings, and forms and modes of proceeding existing at the time in like causes in the courts of record of the state within which such circuit or district courts are held. This enactment only tended to make clearer and magnify the importance of the equitable jurisdiction and practice in equity cases in those courts, which had been a striking characteristic of federal practice, notwithstanding the reformed Code of Civil Procedure adopted so universally in the states, and that England herself has turned its back on the old forms by adopting the code system. The federal courts still continue in the ancient and time-worn path of the formal distinctions originated and discarded by our ancestors. The federal judiciary, many of the judges of those courts having gone from the code states, take pride in building up and fostering a sort of aristocracy of forms and ancient customs, rather than to favor a progressive course leading to the adoption of a system of procedure which tends to simplicity, and to more complete and efficient remedies. Sec. 175. Equity pleading in the United States courts. The term equity pleading has a peculiar significance in the United States. This is so because in the code states the rules and principles of that system have in a large measure been assimilated with, and welded in the code system. On the other hand, equity pleading as it was formulated by the English Court of Chancery, and as it existed in that court at the date of its adoption in this country, has been the mode of procedure in equitable cases in the federal courts of this country since the organization of such courts. There are some states, notably West Virginia, New Jersey, Tennessee, and perhaps others, which still preserve and follow the equity system of procedure substantially in its original form as practiced in England. A practitioner in a code state, therefore, must of necessity become familiar with the equity system in its original form, as modified by the federal equity rules, or as modified in any of the states which still follow it in a somewhat modified form, as well as with the blended system of law and equity under the Code. The finished lawyer will not be content with a mere knowledge of the modified system, but will familiarize himself with the ancient equitable practice as well. It seems remarkable that the federal courts or any state courts should still cling to the ancient practice in view of the fact that the reformed system of procedure has been so universally adopted throughout the United States, and that England herself has followed in the same path of reform that was first adopted in this country. The most interesting characteristic of the federal equity practice is that the United States courts are particular to follow the parent English system as it existed at and prior to the adoption of the original chancery practice in this country, and that such courts refuse to follow or consider the changes made in the original chancery system in England subsequently to the date of its adoption by the federal equity rules in this country. The federal equity courts regard the first edition of Daniel's equity practice published in 1837 being the second edition of Smith's practice published in the same year as their Bible. In such courts these works are considered the most authoritative treatments of chancery practice which were in use in March 1842, when the equity rules were adopted. It is said that these works supplemented by the general orders made by Lords Cottenham and Langdale, in August, 1841, many of which were closely copied in our own rules, exhibit that present practice of the High Court of Chancery in England, which, by our 90th rule was adopted as the standard of equity practice in cases where the rules prescribed by this court, or by the Circuit Court, do not apply. The second edition of Mr. Daniel's work, published by Mr. Headlam, published in 1846, was much modified by the extensive changes introduced by the English Order of May 8, 1845, and the third edition, by the still more radical changes introduced by the Order of April, 1850, the Statute of 15 and 16 Vict. c. 86. And the general orders afterwards made under the authority of that statute. Of course, the subsequent editions of Daniel are still farther removed from the standard adopted by this court in 1842, but as they contain a few of the later decisions bearing upon so much of the old system as remands, they have on that account a value of their own, provided one is not mistaken by the new portions. The conditions already mentioned in reference to the equity practice in the federal courts and in some states make it necessary for student and practitioner to become entirely familiar with the ancient equity system. To accomplish this purpose, the general features and principles of equity pleading, with particular reference to its operation in federal courts, will be considered. Sec. 176. Historical consideration necessary. Equity and law are now administered in nearly all of the American states and England by the same court. To understand the system perfectly it is necessary to consider its origin and history, going back to the time when courts of equity and of law were separate, becoming familiar with the old forms of pleading and practice in courts of chancery, which materially differed from those at law. The origin of the High Court of Chancery in England was due wholly to the inability, and to a limited extent, the unwillingness of the common law courts to entertain and give relief in every case, and thus meet all the requirements of justice. Jurisdiction of common law courts was circumscribed by artificial and technical forms. They adhered to certain precise writs and rigid forms of action which were not sufficiently comprehensive to enable them to give adequate redress in some cases of injustice and wrong, or to give any redress in many others. In such cases the aggrieved was remediless, except he could get a hearing of the king himself. Petitions were therefore frequently presented to the king and by him referred to his secretary, called a chancellor. And in time the Court of Chancery came into existence. There grew up not only two distinct systems of practice in the courts of law and equity, but also two distinct systems of substantive jurisprudence. The codes affected only the formal systems of practice, substituting one system without disturbing the two systems of jurisprudence. Learned men have contended that the inherent distinction between a right of action in law, or in equity ought likewise to be abolished to make the transformation complete and perfect. It will be helpful to consider some of the difficulties and disadvantages connected with the two formal systems previously existing, as it will shed light on the new one taking their place. There were many instances where it was difficult to determine whether a matter appealed to the court of law or to a court of equity. If a suitor mistook his remedy and went into the wrong court, his cause would be dismissed and he would have to go into the proper court by a new suit. It was argued by the framers of the code that chancery practice was a standing proof of the imperfections of law practice. England began with one system of practice which in course of time proved defective. This brought into existence the system of equity practice, which was not an original, independent system, but simply a mandatory and corrective of an old one. The most serious drawback to two separate and independent formal systems of practice was the fact that parties litigant could not settle their controversies existing between them in one action. If one brings a legal cause of action against another, the latter could not by cross-bill have an accounting between them, even though that might wholly change the rights of the parties by showing that plaintiff could not recover. A code practitioner who may happen to be called upon to defend an action in the courts of a common law state will fully appreciate the disadvantages of the old systems. For example, suppose that A sues B in a sumpsit on a promissory note in the courts of West Virginia. Suppose that A and B have been partners, and that B has given a promissory note upon which the action is based. Suppose that upon an accounting between the parties, which formerly could have been had only in equity, it may be shown that A is in fact indebted to B in a sum almost equal to the amount due on the note. Notwithstanding this fact, B will have to submit a judgment on the note and obtain an accounting by an independent suit in Chancery, and upon ascertaining the amount due him from A he can offset it against the note. These imperfections in the practice of the common law and equity system as they were followed in England still stand out prominently in the states which still pursue the old system and in the federal courts throughout the United States. A legal defense could not be interposed to an equitable action nor an equitable claim be set up in a legal action, but the legal or equitable action must proceed to final termination and the party with the legal or equitable claim must resort to an independent suit in order to establish such claim. The union of the two systems into one, enabling a defendant to set up as many defenses, counterclaim or set-offs as he may have, whether legal or equitable, avoids a multiplicity of suits, saves costs and trouble to litigants. Sec. 177. Distinction between courts of law and of equity. The chief distinction between courts of law and of equity, is in the modes of proof, degrees of proof, trial and relief. It will be generally found, that they harmonize as to principles of the common law, in the application of its remedies. In common law practice it was incumbent on plaintiff to make out his case satisfactorily either by oral testimony or by written documents. If, however, material written instruments should be lost, or if the facts necessary to substantiate a cause be known only to the parties to the action, plaintiff under the old common law procedure would suffer defeat. In equity the party may have discovery upon oath. In procedure in common law courts all the witnesses were examined viva voce, while in courts of chancery testimony of witnesses was always taken in the form of written depositions. Equity affords specific relief, as by compelling specific performance, reformation, rescission, injunction, as compared with money damages at common law. Sec. 178. Analogies and distinction of pleading in equity and at common law. Some early writers contend that there is strong analogy between the pleadings in equity and those at common law. The procedure in general in equity was similar to that in common law actions, but differed radically in many particulars. There was strong analogy in the substantive law in the two systems, especially in the construction of contracts, in the relative rights and duties embraced in the legal or equitable obligations. There was no essential difference in the principle or rule of conduct applied in the administration of justice in the two tribunals. The distinction related to the mode and forms of the remedy as well as the remedies themselves. The common law action was begun by the issuance of the original writ which required defendant to repair the injury complained of, or to appear in court, and show cause to the contrary. The declaration filed subsequently was but an exposition or amplification of the writ. Proceedings in equity were commenced by a petition to the court, to issue the king's writ of subpoena, to compel the defendant to appear, and answer concerning those things which shall be objected to him, and farther, to do and receive what the said court shall have considered in that behalf. The petition stated the cause of complaint, and in earlier equity practice, articles in writing were exhibited to defendant when he appeared, containing charges which he was required to answer under oath. It was afterwards found more convenient to insert these charges in the body of the petition itself, which was then denominated a bill in Chancery. The primary object and purpose of the bill was to obtain a discovery upon oath from defendant. Because of this, it followed that the bill, quite unlike the declaration, states a great variety of facts and circumstances. The plaintiff in his bill usually anticipated and controverted the defense of the adverse party. The declaration in common law practice was a pure pleading, confined to a single and simple statement of injury. The same modes of defense prevailed in equity as at law. The answer was required to be an answer upon oath of the several allegations of the bill, and in this respect it performed the function of an examination, as well as of complaint. If the answer denied the allegation of the bill, then it was regarded as a plea, and was analogous to the general issue at law. The several parts of an answer were: 1. A traverse. 2. Admission of facts. 3. Confession and avoidance. The plea in equity is similar in form, substance and effect to a plea at law. Pleadings in equity terminated with the replication, whereas they may proceed at law to the rebutter and zur rebutter at law. Pleas were of three classes: 1. To the jurisdiction. 2. Pleas in abatement. 3. Pleas in bar. Pleas in abatement and in bar were the same at law and in equity. The general rules applicable to pleas at common law applied to the construction of pleas in equity. A demurrer performs the same office in equity as at law. Sec. 179. The Supreme Court of the United States has power to regulate the practice. While Congress has power to regulate the practice in the federal courts, it has chosen to delegate that function primarily to the Supreme Court, authorizing it to formulate rules prescribing the forms of proceedings in equity. Congress, however, distinctly provided that the forms of meson process and the forms and modes of proceeding in suits of equity and of admiralty and maritime jurisdiction in the circuit and district courts shall be according to the principles, rules, and usages which belong to courts of equity and of admiralty respectively, except where it is otherwise provided by statute, or by rules of court made in pursuance thereof, but the same shall be subject to alteration and addition by the said courts, respectively, and to regulation by the Supreme Court, by rules prescribed, from time to any circuit or district court, not inconsistent with the laws of the United States. The Supreme Court, proceeding under the authority of the Act of May 8, 1792, promulgated rules of procedure in equity in 1822. In 1842 a statute was passed by Congress which provided that the Supreme Court shall have the power to prescribe from time to time, in any manner not inconsistent with any law of the United States, the forms of writs and other process, the modes of framing and filing proceedings and pleadings, of taking and obtaining evidence, of obtaining discovery, of proceeding to obtain relief, of drawing up, entering, and enrolling decrees, and of proceeding before trustees appointed by the court, and generally to regulate the whole practice, to be used in suits in equity or admiralty by the circuit and district courts. In pursuance of this authority the existing equity rules were promulgated March 2, 1842. These rules were for the most part based on the English rules of equity practice. The student of equity pleading and practice will obtain a better view of the ancient practice by giving his attention to the federal equity, and his examination will be more fertile because he will be always pursuing a live wire. Sec. 180. The name of the proceeding in equity. The proceeding in a court of equity for the redress of wrongs is called a suit, as distinguished from an action in common law procedure. Sec. 181. Suit in equity. How commenced? A suit in equity is commenced in the proper court by filing either a bill or information. Formerly, when the government instituted actions in equity, the initial pleading was styled information, while in suits commenced by private persons the first pleading was called a bill. While this distinction still prevails in theory, it has become practically obsolete, all suits by either the government or by individuals being now commenced by the filing of a bill. Sec. 182. Kinds of bills. Bills were divided into two kinds: viz., original bills and bills not original. Some writers place little value on this classification, it being suggested that the word dependent gives expression to the most striking feature of bills that are not original bills. 3. An original bill is one that begins the action, while a bill which is not original is one that either is for the purpose of continuing a suit begun by the original bill, such as a bill of reviver, or one which is for the purpose of cross-litigation, or to suspend, or reverse some decree. To undertake to classify original bills would result in an enumeration of equitable remedies, such as a bill in account, for cancellation, discovery, injunction, and the like. Original bills are again divided into those which pray for relief, and those which do not pray for relief. Bills praying for relief embrace the bill of certiorari, the bill of interpleader, and the ordinary bill for relief. A bill of certiorari is for the purpose of removing a suit from an inferior court of equity to a superior court. A bill of interpleader is brought by one who has money or property in his possession, which is claimed by two or more persons who are in controversy over the same. It is brought for the purpose of having the court adjudge to whom the money or property belongs so as to relieve the stakeholder of responsibility. A regular or ordinary bill for relief is one which seeks a decree from the court touching some right, claimed by the party exhibiting the bill, in opposition to some right, real or supposed, claimed by the party against whom the bill is exhibited, or touching some wrong done in violation of the plaintiff's right. Illustrations of bills not praying for relief are: 1. The bill to perpetuate testimony, 2. The bill of discovery. Sec. 183. Formal parts of bill in equity. It was formerly supposed that every bill should consist of 9 parts. But at no time in the history of the equity system were all of these formal parts deemed essential. In code practice there is no practical use for any of them, the interest of the code practitioner in them being of mere historical nature. But as every lawyer is expected to be ready to conduct litigation in federal courts, it is essential for practical reasons that he should become familiar with equity pleading. The 9 formal parts of a bill in equity are as follows: 1. The address. 2. The introduction. 3. The premises or stating part. 4. The confederating part or clause. 5. The charging part. 6. The clause or jurisdiction. 7. Interrogatory part. 8. The prayer for relief. 9. The prayer for process. The old arrangement of the several parts of a bill into 9 parts, to be found in all the books, was regarded by some writers of no great utility, some of the classes or parts being of such little importance, that the validity of the bill would remain unaffected if they were entirely omitted. Luke divides the bill into 4 parts. 1. The circumstantial statement of the relation, including the inducement or introductory part. 2. The incidents which produce the grievance complained of, including the requests made to the defendant, and his refusal. 3. The statement of such collateral circumstances, if necessary, by way of charges may compel the defendant to acknowledge the grievance, on which may anticipate and controvert his defense. 4. And lastly, by reason of the foregoing complaint, and for want of adequate remedy at common law, it concludes with a petition for the subpoena, to the end that the defendant may answer the premises, and the court decree relief. Sec. 184. The address. The first part of the bill is the address to the court in which it is filed. Originally in England, it was addressed to the Lord Chancellor, the custodian of the Great Seal. The purpose of this part is to give the technical description to the court in which it is to be filed. Though not essential, it is customary both in state and federal courts to give the name of the judge of the court. The address may be either above or following the captain, preferably the latter. The name of the court should be placed at the top of the bill, as in code petitions, followed by the caption, after which follows the address, to the Honorable, the judges of the Circuit Court of the United States within and for the Southern District of Ohio sitting in equity, or the State Court, to the Honorable U.B. Staley, Chancellor, holding the Chancery Court at Knoxville, Tennessee. In English practice the first part commenced as follows: humbly complaining, shout unto your lordship, your orator, A. B. that, etc. This was so framed as to be both a petition and a complaint. The words humbly complaining, showeth, styles the complainant not a petitioner, but an orator, to mark a distinction between a bill and a mere petition. Sec. 185. Introduction. The second part of the bill is the description which states the names, description and the place of abode of the plaintiff. This is for the purpose of fixing the identity of the parties, for all the purposes of the case, such as the enforcement of the payment of costs, and the obedience of the court. In this part of the bill filed in the federal courts, the citizenship of all the parties, both plaintiffs and defendants, must be set out. This is necessary to meet the requirements of jurisdiction of those courts, depending as it does, in some cases, upon the facts that the controversy is between citizens of different states. Equity Rule Number 20 prescribes the form A, B, of, and a citizen of the state of brings this his bill against C, D, of, and a citizen of the state of, and D, F, of, and a citizen of the state of, and thereupon your orator complains and says that, etc. Anciently the second part of the bill commenced, and your orator hath frequently and in a friendly manner applied to and requested, as equity and good conscience required of him. And your orator well hoped that such, his just and reasonable requests, would have been complied with, as in justice and equity they ought to have been, but now so it is, etc. Sec. 186. Names of parties. The same rules of statement of the Christian and surname, as obtained at law, and in code practice, applies in equity practice. The designation of persons by their initials is condemned in the federal courts, as it is in code procedure. Sec. 187. Stating or narrative part. This part of the bill must contain all of the facts necessary to constitute the cause of action. The same rules should be observed in the statement of this part of the bill as in code practice. While there may have been much more formality in the ancient practice, there is now no difference. Modern modes of expression prevail, and every material fact is stated which the plaintiff expects to offer in evidence. It is not necessary to charge minutely all the circumstances, a general charge or statement, only, being sufficient. No evidence can be introduced unless the facts are alleged, so that relief is limited only to those facts alleged. The same rules of pleading apply to the statement of facts as do in code pleading. For example, evidence and legal conclusions should not be alleged. Greater liberality has always been exercised in equity pleading, the principle of flexibility having been constantly maintained in the interest of substantial justice. The early writers urged that the equity pleader should adhere to the common law rules of pleading whenever those rules were applicable to the cause presented in equity. General allegations of fraud were as improper in equity as they were in law. Sec. 188. The confederating part contains a general allegation of a confederacy between the defendant and other persons to injure or defraud the plaintiff. The practice is said to have arisen from an idea, that without such a charge parties could not be added to the bill by amendment, but it is claimed that new parties could be added at that time. Then follows the confederating part, i.e., the defendant confederating with others to oppress and defraud the complainant, refuse to do what is just. The third part is generally introduced by a statement, that the defendant makes various pretenses to justify his refusal, the contrary of which the complainant charges to be true, and then proceeds to make such other charges as either corroborate his statements, or controvert the defense likely to be adopted by the adversary. The form was as follows: and to continue such his unjust conduct, the said defendant sometimes pretends that, following some matters of excuse or matter will discharge him from a liability. Whereas your orator charges the contrary to be true, following with the statement of facts which would counteract the excuse of defendant. And the whole concludes with the averment, all of such actings, pretenses and refusals of the said confederates are contrary to equity and good conscience, and tend to the manifest wrong and injury of your orator in the premises. The reason for this part of the bill is grounded on the historical fact that concerning the evils which resulted from alleged combinations and confederacies on the part of powerful persons to prevent the ordinary administration of justice. Federal Equity Rule Number 21 provides that the plaintiff shall be at liberty to omit, at his option, this part of the bill. In cases, however, where the plaintiff's right actually arises out of some conspiracy, this part of the bill becomes an essential part thereof. Sec. 189. The clause of jurisdiction. In this part of the bill there is a general averment that shows that the acts complained of cannot be completely remedied at law and hence are within the jurisdiction of equity. And yet the same kind of allegations are still improperly made in code practice in equity cases. For example, an allegation that plaintiff will suffer irreparable injury or that he has no adequate remedy at law, are conclusions and improper, and are the same allegations as were previously made in this clause in the Chancery practice. Federal Equity Rule No. 21 provides that this allegation may be omitted without subjecting the bill to admira. The suggestion is made in a recent work, however, that it may yet be sometimes desirable for the plaintiff to point out explicitly that he has no adequate remedy at law, and to show wherein the inadequacy of the legal remedy consists. But it is inconceivable that there can ever be any necessity for use of this clause under any system of practice. The facts as they appear in the stating part of the bill are the sole guide to the court in determining whether it is a case that appeals to a court of equity. Sec. 190. The charging part. This part consists of some allegations, setting forth the matters of defense, or excuse, which it is supposed the defendant intends, or pretends to set up, to justify his non-compliance with the plaintiff's claim, charging other matters which disprove or avoid the supposed defense or excuse. This is, in other words, anticipating a defense which was not permissible at common law. As Chief Justice Hale put it, it is like leaping before one comes to the stile. It is sufficient that each pleading should, in itself, state a prima facie case without reference to what a defendant may allege, and this is the rule under the reformed system. This part of the bill was used for the purpose of obtaining a discovery of the defendant's case, or of putting in issue some matter which it is not for the interest of the plaintiff to admit. It seems to be well established, though there was some dispute about the question, that the material facts showing the plaintiff's equity should generally appear in the stating part of the bill rather than in the charging part. This part of the bill may be omitted when the facts disclosing the plaintiff's cause are fully stated in the stating clause. In the original practice, this part of the bill was frequently used to obtain a discovery of the defendant's case. To this end it often contained fictitious statements resulting in disreputable practices and oppression of defendants. Misstatements were made in this part of the bill for the purpose of grounding interrogatories upon them. It was urged by some, that as making of these misstatements was a prerequisite or preliminary for putting many questions to the defendant, which he ought, for the furtherance of justice, to answer. The practice was justifiable, and should not be checked. Judge Story states that though the equity of the case is fully stated in the stating part, all the objects, intended to be accomplished by enforcing a discovery of the circumstances in the charging part, may be fully allowed by interrogating the defendant, especially as to the facts material to the case. Indeed, he says, until a comparatively recent period, the charging part constituted no distinct allegation of the bill. Lord Eldon insisted that the interrogating part had its birth before the charging part, and that proper practice required the latter to be little more than an enlargement of the statement. Special attention may be directed to the statement made to the effect that this part of the bill was designed to lay the foundation for discovering the nature of the defendant's case. It may be imagined that if this course was permitted, that is, if the interrogatories extended to matters beyond plaintiff's title or case, reaching defendant's case, it would necessarily follow that this part of the bill would state matters variously by way of anticipating what defendant's side of the controversy might be, so as to lay the foundation for interrogating defendant as to his side of the case. This would undoubtedly result in the statement of suppositions. It is contrary to our notions that interrogatories may be permitted which do not relate exclusively to plaintiff's title and to his own side of the controversy. In a recent excellent work on federal equity practice, special stress is laid upon the importance and necessity of this part of the bill, which seems significant in view of Judge Story's view that it is not indispensable and may often be omitted, but it would seem from his treatment of the subject that the practice must have materially changed from its original simplicity in this matter. Professor Street holds that every bill assumes a double aspect, that it must contain a statement of facts on which relief is sought, and a statement of matters of evidence in regard to which discovery is desired, that in drawing bills the pleader must state the evidence for the purpose of obtaining discovery, but for other purposes he need only state the facts. that the common mode of complying with this rule is, first, to state the facts in the stain part, or charge the evidence of those facts in the charging part of the bill. The bill subserved the purpose not alone of a pleading to bring before the court and put in issue the material facts upon which the complainant's right to relief rests, but also may perform the function of an examination of the defendant for the purpose of obtaining evidence to establish the complainant's case, or to counterprove or destroy the defense which the defendant may attempt to set up. The complainant may state any matter of evidence, or any collateral facts, the admission of which, by the defendant in his answer, may be material in establishing the allegations of the bill as a pleading, or to ascertain the nature, extent and kind of relief to which the complainant is entitled. Sec. 191. General Interrogatories. The interrogating part of the bill has a dual aspect. In the original practice there was a general interrogatory which calls upon the defendant to make a full, true and perfect answer to each and every allegation of the bill, or asks the court to require the defendant to appear in court and answer the allegations of the bill. The general interrogatory is found near the end of the bill. The plaintiff may require that the answer be made under oath, or he may waive the oath. If does so waive, the general interrogatory, nevertheless, is inserted. It is considered that the general interrogatory is not dispensed with, even by the use of special interrogatories. A rule of the Federal Supreme Court dispensed with the necessity of the general interrogatory by requiring the filing of special interrogatories. But by an alteration of the rule at a later period the old practice of using the general interrogatory was reenacted. Sec. 192. Special Interrogatories. Special interrogatories are inserted at the end of the bill and consecutively numbered so that ready reference can be made to them. Introductory matter to interrogatories is prescribed by Rule 43, Federal Equity Rules, which may or may not be followed according to the choice of the pleader. Sec. 193. Interrogatories confined to the bill. Interrogatories may only be attached to the bill, and may not be propounded to the plaintiff in the defendant's answer. A cross-bill, however, may be filed by a defendant for the purpose of compelling discovery from the plaintiff. If a defendant is unable to make a full defense without the possession of facts which rest in the knowledge of the plaintiff, he may file a cross-bill for the purpose of procuring discovery of such facts. Sec. 194. Interrogatory is not permitted in actions at law in federal courts. It is a singular fact that the federal courts do not follow the practice of code states in actions at law, and do not permit the use of interrogatories in such cases, even though the state practice authorizes it in such cases.